Hello, I'm Alex Charns, and I'm author of FBI Snitches, Blackmail, and Obscene Ethics at the Supreme Court. I worked on this book for 42 years, started in 1983. I'll give a little bit of that history. Filed 3 lawsuits against the FBI, won each one of them, and let's begin. So very happy at the review from Kirkus Reviews, riveting, damning indictment of the FBI's illegal activities under its founding director. And how did this all start? It was a FOIA request in 1983 for all FBI files about the Supreme Court. Dave Garrow was teaching at Chapel Hill in the history department. He published his bombshell book, The FBI and Martin Luther King Jr., about the Bureau's bugging, wiretapping, informants, and threats against King. And I wondered, did the FBI do the same thing to the Earl Warren Court? So that's what I thought, and that's why I decided to make a FOIA request. There's the Earl Warren Court 1966. There's Abe Fortas, who will become important later. There's J. Edgar Hoover. So don't do this. This is how I did my request. Any files or documents relating to present or past FBI surveillance of the Supreme Court, including attempts to influence its decision making, attempts to gain copies of court opinions prior to public release, and the use of informants or sources within the court, including justices, clerks, clerical, administrative, or other persons involved in carrying out the court's day-to-day functioning, to allow the Bureau access to the inner workings of the court, in addition to any other FBI programs directed at the Supreme Court from 1924 to the present time. The FBI evidently wasn't happy about this request because they ignored it for months and months and months. Finally, they got back to me and said, "We have no file called Supreme Court." So I consulted Professor David Garrow, winner of the Pulitzer Prize for his Martin Luther King biography, Bearing the Cross, and he said, well, he didn't believe they didn't have a file. I didn't believe they had a file, so I asked for every deceased justice's FBI file going back to the 1920s. I also asked for my own file, and in it I found this search slip. And there is 62-27585. That file turned out to be 2,000 pages long. And it was called Supreme Court. What else I found out in my own file was that the FBI found this file in 1983 right here and told me it didn't exist, but also granted me a fee waiver for release of some of these files in that file because it was in the public interest. So, they released in 1988 this 2076 page file called Supreme Court that I requested in 83. They granted me a fee waiver and told me it didn't exist back then. So conspiracy, cover up, or just gross incompetence. I'll let you decide. So the New York Times covered this disclosure, gave me credit, and it included suspicions by the Bureau of Communist influence on the court in the 50s and the use of court employees as sources of information, including the marshal, the clerk of court, and the Supreme Court police. I also did an op-ed in the Washington Post in 1989, how the FBI spied on the High Court. So, lawyer up. That's what I did. There's Paul M. Green, my lawyer, a pit bull of a FOIA lawyer and a good friend. So, what we were contending with was the do not file filing system. It was a separate filing system created by Hoover for warrantless buggings, warrantless wiretaps, and burglaries. So FBI agents could testify in court that they searched the central record system index and located nothing. Evidence of unlawful FBI contact was kept separately. The most important of these do not file files was J. Edgar Hoover's official and confidential files kept in his office. We succeeded in uncovering a folder concerning a warrantless bugging case, the case of Fred B. Black Jr., which in 1966 appeared on the docket of the Supreme Court. Fortas was the subject of that folder, but was indexed under Fred Black's name, so the FBI could say, oh, we don't have a folder on Abe Fortas. So, 1966, let's go back in time. LBJ was president, Earl Warren Chief Justice, Thurgood Marshall Solicitor General. Nicholas Katzenbach was the Attorney General. So this was the biggest threat to Hoover's power, 1966, warrantless buggings, and the case before the Supreme Court could end Hoover's career. Here's Abe Fortas. The FBI goal, blame Bobby Kennedy, the former Attorney General. LBJ and Hoover hated Bobby Kennedy. Solution, they needed a mole on the court. Justice Fortas continued to serve as LBJ's advisor while he was on the court. He worked closely with the FBI on President Johnson's behalf. Blaming Bobby Kennedy would be helpful to LBJ politically. Would Justice Fortas violate his judicial oath? Senator Edward Long threatened to investigate the FBI about its electronic surveillance practices, but after talking to by FBI official Cartha DeLoach, the threat of his investigation was, quote, neutralized. In 1966, Herblock, the political cartoonist, wrote, wiretapping and bugging have amounted to major weapons, not so much against crime as against privacy. These bugging cases, here's Fred Black behind my picture. He was a disgraced lobbyist. There's Cassius Clay, later Muhammad Ali, Jimmy Hoffa, and there is Kennedy and LBJ. So all of this scandal was involving a spike microphone. There's the spike, there's the microphone. It was pounded into the wall adjoining the suite they were looking to bug. It was a clear Fourth Amendment violation. So we continued litigating the inadequacy of the FBI's search for records and hit the jackpot. Here was proof in the folder called Fred B. Black Jr. that had been kept in Hoover's office, that Fortas had acted as a high-level FBI informant on these wiretapping cases, informed on the other justices about their conversations in the conference room, and later looking at Fortas's papers at Yale Law School, I also determined that Fortas was passing blind memos to the other justices, even though he disqualified himself in this case. So, Fred B. Black versus United States. The court ruled that the case had to go back for a new trial because the FBI had picked up the conversations between Black and his lawyer. Hoover survives this scandal with the help of Justice Fortas, and there was mention of the FBI, but no mention of Hoover in this per curiam opinion, which means it was signed, not signed, it was by the whole court. And at the bottom of the opinion, it said Mr. Justice White and Mr. Justice Fortas took no part in the consideration or decision of this opinion, which wasn't true. White did some lobbying. He had been in the Justice Department with Bobby Kennedy and was a Kennedy advocate. Fortas, of course, committed the most egregious judicial ethics violations in the history of the court by serving as an informant for the FBI in the White House. So that was my decades-long FOIA journey. In 1992, I published Cloak and Gavel, FBI wiretaps, bugs, and informers in the Supreme Court, but the litigation wasn't over. It was still going on. This was the Wheel of Fortune segment of the litigation. We didn't believe they had given us everything about Fortas or the court, and the FBI claimed they had no index of Hoover's official and confidential subject folders. That wasn't true because Professor Athan Theo Harris, the foremost authority on the Bureau, had received an index from the FBI years previously. So between folder 70, Foreign Influence in the Black Extremist Movement, and folder 72, Foxworth PE, was a blacked out name. And Paul Green figured it out playing Wheel of Fortune. He counted out 11 letters, a comma, and a space. And we went to the court, filed a motion to disclose this file on Abe Fortas. And when we showed up in Greensboro in the hallway, we were given this blackmail file that included this memo. Attached memorandum from the Washington field office reflects possible homosexual activities on the part of Justice Fortas. Tolson and Deloach recommend that a memorandum be prepared forwarding this information to the Attorney General. Hoover, here's his JEH initials at the bottom. He says, no, Deloach should see Fortas. The process at that time was very a harsh, cruel atmosphere against gay people. There was a homosexuality in government program to root out gay people. So there's Cartha Deloach. There is a picture of Justice Fortas. And Deloach, the third in command at the FBI, met with Fortas at Fortas's home. And the FBI memo was shown accusing Fortas of having sex with a teenage boy. Fortas denied wrongdoing, but the FBI said, your secret is safe with us, and it certainly was. Here's a memo from Deloach to Tolson, and it's filed under Abe Fortas's name in these Hoover's official and confidential files. And in it, he recounts the meeting with Fortas and telling him, don't worry, we're not going to do anything with this file. And Fortas continued to rule on FBI cases after 1967, though he had been blackmailed while a sitting justice. This secret was safe for 3 decades. The Senate didn't learn of it when Fortas was nominated to be Chief Justice and then resigned in disgrace due to an unrelated financial scandal. The Senate Select Committee on Intelligence didn't learn of it, historians didn't learn of it, and journalists didn't learn of it. I rewrote Cloak and Gavel as FBI Snitches, Blackmail, and Obscene Ethics at the Supreme Court. The book is free to download on Amazon, 2/12/25 through 2/16/25. And I hope you'll take a look and let me know what you think. And there is the sunshine that the Freedom of Information Act allowed me and my lawyer Paul Green to shine on the situation. So be well, good FOIA hunting, and I hope you'll take a look and again let me know what you think.